The best friend is trustee of a dentist's $750,000 life insurance policy, and for 16 years the system worked. The insurer mailed the premium notice to the friend as trustee. The friend called the wife, who deposited money into the trust's bank account. The friend then paid the premium on behalf of the trust from that bank account. Every time for 16 years, until the friend moved 2 months before the next premium was due. The friend filed mail forwarding with the post office, but never updated his address with the insurance company, never told the dentist, and never noticed that for the first time in 16 years, the dentist's life insurance premium didn't get paid. 2 months after the friend moved, the dentist's life insurance lapsed for non-payment. No one noticed that either, including the insured dentist. 5 months later, the dentist died. And instead of paying his widow $750,000 in life insurance, she got nothing. A federal court sided with the insurer, who refused to pay. But it gets worse. 3 days after the dentist died, the friend as trustee called the life insurance company. He never told them the insured had already died. He convinced them to reinstate the life insurance policy as a one-time exception. The friend paid the back premiums. The friend got written confirmation. But when the insurer found out that the insured had died before the reinstatement, they voided the life insurance policy again. When the widow found out, she sued everyone. The life insurance company, the friend as trustee. The friend trustee's best defense? He blamed the widow for contributory negligence because she never put money into the trust bank account for 2 payment cycles. She never asked why no one was calling about premiums. She never noticed 6 months of silence. The court held that argument, contributory negligence, can go to a jury. In episode 110, Life Insurance Trust That Lost $750,000, Friend Trustee Blamed the Widow, we examine how naming a friend as trustee instead of a professional led to the total loss of a $750,000 life insurance policy. Explore the recorded phone call that turned a tragic mistake into potential trustee fraud, and analyze the court's ruling on who was responsible, including whether the widow's own inaction cost her the claim. Join us to see how it litigated.
When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lease Murray, J.D., lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong, so you get it right. And now, here's your host, Professor Kelly Lease Murray.
I'm Kelly Lease Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We break down actual court cases that impact your professional practice and your client's wealth outcomes. Let's gavel in. What happens to an irrevocable life insurance trust when the underlying life insurance policy lapses from non-payment of premiums? In a word, litigation. For Orchin versus the life insurance company and Gadaire versus Orchin, 2 cases consolidated before the federal district court in Washington, D.C. We start with what's at stake. For the widow, does she receive $750,000 in life insurance, either from the insurance company or from her separate litigation against the friend trustee who failed to make the insurance premium payments? What about the trustee? What's his responsibility, and more importantly, what's his legal liability for the non-payment of the premiums that for 16 years he had paid in full on time twice a year? And finally, what about the irrevocable life insurance trust itself? What was its purpose, and did it actually protect anyone? Between these 2 consolidated lawsuits, there were 3 legal issues. First is the termination. Did the life insurance company correctly terminate the life insurance for non-payment of premium? Second, the factual reinstatement. Was the reinstatement enforceable? And because of the reinstatement, did the life insurance company owe the widow $750,000? And finally, the litigation between the widow and the trustee. What was the trustee's responsibility? Did he breach his fiduciary duty? And was the wife subject to a contributory negligence defense? The key facts begin in 1975 when the insured dentist applies and is accepted as part of a group life insurance policy program. In 1993, he transfers his interest in this life insurance policy from himself personally to an irrevocable life insurance trust. And I want everyone listening to put a post-it on that fact. Owning a life insurance policy means you personally can communicate with the life insurance company. The life insurance company has to send you the premium notices. You can personally log in to see the status of the policy itself. But when you transfer a life insurance policy from yourself personally to an irrevocable life insurance trust, you no longer own the policy. Your beneficiaries may not have changed. It may be your spouse, it may be your family, but the owner of the policy is no longer you, the insured. The owner is the irrevocable trust, and the person who represents the irrevocable trust is the trustee. For Orchin and Gadaire, that's happened in 1993, where the Gadaire life insurance policy was transferred to an irrevocable life insurance trust, and the trustee was Orchin, a friend of the insured dentist and his wife. The beneficiary remained the wife. The premiums were paid twice a year, biannually. Make sure you check your policy. It could be due once a year, but under these facts, it was twice a year, January 1st and July 1st. For 16 years, from 1993 through January 1st of 2009, the trustee for this irrevocable life insurance trust made those premium payments in full and on time, to the point that the policy did not lapse within that period. And this is how the system, the payment loop, worked for 16 years. No problems, no glitches. The insurance company mailed a notice to the trustee. The trustee called the wife. The wife deposited the money into the trust's bank account. The trustee paid the insurance company the biannual premium out of the trust's bank account. The timeline here is critical. January 1st, July 1st, those are when the biannual life insurance premium payments were due. 2 months before the July 1st, 2009 payment was due, the friend trustee moved, and that is what changed everything. The trustee moved. He filed a notice of change of address with the post office, but he never received the July 1st, 2009 premium notice from the insurance company. That's a fact. How does it play out legally between the insurance company and the responsibility of the trustee to the widow who's the beneficiary? That July 1st payment, 2009, missed, not paid. According to the insurance policy itself, there's a 31-day cure period. So between July 1st, 2009 plus 31 days, if the premium had been paid, the policy would not have lapsed. Well, 32 days pass and no payment is made. The insurance company mails another notice informing the trustee that the policy has lapsed. But he has moved and he did not receive the notice of the policy lapsing either. But 5 months later, the January 1st, 2010 payment was technically due as a fact for the dentist, his wife, and the trustee. None of them noticed, and within 2 weeks of that non-payment of premium, the dentist insured passed away on January 15th, 2010. 3 days after the dentist died, something else happened. The phone call gives us insight into the mindset of the trustee and the mechanics of a lapsed insurance policy owned by an irrevocable life insurance trust. But before we tackle any of that, there's one rule we all need to focus on straight away. When a life insurance policy is transferred from the owner, the insured's life, to an irrevocable life insurance trust, the owner is the trust. The insurance company only needs to communicate with the trustee of the trust. If the trustee is your friend is the only one communicating with the insurance company. If the trustee is a professional trustee, same dynamic. Many insureds don't realize the difference in ownership and the consequences of that transfer in ownership. The insured and the beneficiary, who may not change despite the transfer in ownership to an irrevocable life insurance trust, may assume that you'll still receive from the insurance company the premium notices. You'll still be able to log in to see the status. That is not automatically true. What everyone needs to take away from this is the following. Make sure you, as the insured, and your beneficiaries have shadow statements or the ability to log in to the life insurance account for this policy. Make sure you've calendared when those premiums are due. Make sure you confirm that they were paid in full on time. Make sure you don't wait 30 days or more from the due date of the payment, because you have a period to cure late or incomplete payments. It's in your client's best interest to stay on top of this, despite transferring the policy ownership from personal ownership to controlled by an irrevocable life insurance trust. In episode 103, we covered a different type of litigation involving an irrevocable life insurance trust. Have a look at that episode for more information. But for purposes of this episode, when you see this combination, your risk radar should start ringing. The Federal District Court, which is a trial level court, ruled as follows. First, that the insurance company correctly denied payment of the $750,000 in life insurance due to the 6 months earlier lapse in coverage from non-payment of premium. The court also held that the reinstatement was not, in fact, a reinstatement, again, no coverage, and that the third issue, the widow's litigation against the trustee, she and her lawyers filed a motion for summary judgment. That's a substantive motion to resolve the litigation without going to trial. The widow's summary judgment motion was denied without prejudice, and interestingly, the district court invited her to refile based on 2 issues that weren't fully briefed. We'll have a look at that coming up. We need to examine the language in the certificate of insurance and the trust agreement that controlled all of this litigation. The certificate of insurance had 2 key provisions. One, it was governed by Illinois law, and that made all the difference in the litigation between the trustee on behalf of the trust against the life insurance company. Also, the certificate of insurance had a 31-day cure period, that if the premium was not paid and was in default, there were 31 days to cure. 31 days after a January 1st missed payment, 31 days after a July 1st missed payment. The trust agreement provided 2 things relevant to this litigation. All premium notices shall be mailed to the trustee with a copy to the grantor. When you read that language, what does that mean to you? The first thing to look at is who is governed by the trust agreement. The grantor, who is the insured dentist, his wife's the beneficiary, and the trustee, the friend trustee. That's it. This irrevocable life insurance trust did not control the insurance company itself. The provision that a copy of premium notices would be sent to the grantor, that means the insured life, the dentist, the insurance company did not have to honor it. In our takeaways, we're going to look at how to improve that provision based on the individuals who were governed by the trust agreement itself. And finally, the duty of care owed by the trustee was written into the irrevocable life insurance trust. The trustee is not liable where such trustee has exercised good faith and ordinary diligence. Based on the facts of this case, did this friend trustee exercise good faith and ordinary diligence in what ultimately turned out to trigger the non-payment of the life insurance policy premiums? What were the arguments raised on these 3 core legal issues? The trust argued that the insurer had a copy of the trust itself and failed to mail to the grantor, the insured dentist, as the trust required, the insurance premium notices, and that District of Columbia law should apply, and they have a consumer protection provision that would have saved this result on behalf of the trust, the trustee, and the widow. The life insurance company argued that the governing law was Illinois. Illinois does not have the same consumer protection provision as Washington, D.C., and Illinois only requires proof that the notice was mailed, not proof that it was actually received by anyone. Bottom line, if Illinois law applies, the insurance company prevails. For the second issue, reinstatement, there is a phone call we're going to look at word for word. Factually, 3 days after the insured dentist died, the friend trustee called the insurance company to get the insurance policy reinstated. The friend trustee did not tell the insurance company that the insured dentist had already passed away. Imagine what the life insurance company's argument was. It was simply, we cannot reinstate a life insurance policy when the insured has already passed away. That's their defense. And then finally, the breach of fiduciary duty. This is the widow suing the trustee. What was the standard of care as a matter of law, and could the district court decide it on a motion for summary judgment, or is that something the jury needs to decide? The friend trustee also had some defenses. First, that he met the standard of care, and second, that the widow contributed herself under a theory called contributory negligence, and applying contributory negligence would reduce any amount he may owe her for the non-payment of the insurance premium due to its lapse. The phone call. This occurred 3 days after the insured dentist died. The trustee friend called the insurance company and said the following: I'm the trustee of a life insurance trust for a friend of mine, and I think I need to clear up a discrepancy in billing. I'm feeling so guilty. I've been a trustee for 15 years and I've never let it slip, and I don't want them to know I did this. There must be a way that I can pay the past monies. That's the transcript of the phone call. Factually, the trustee, who did not disclose that the insured dentist had already passed away, factually, the trustee paid the two non-payment premiums. So he got the policy up to date, paying the past due July 2009 policy premium and paid the January 2010 policy premium. But is that reinstatement legally valid? The trust argued that the insurer in fact reinstated the policy, sent written confirmation, accepted the money. The insurer obviously rejected that, asserting you cannot insure a life that has already ended, citing Illinois precedent going back to 1884. The insurance company won on that issue. But it brings us to who pays what to whom across all three of these legal issues. The holding on the first is that the insurance policy lapsed as of August 2009, approximately 6 months before the insured dentist passed away. That Illinois law did govern the interpretation of who has to mail the premium and who has to receive it. Under Illinois law, the insurance company only had to mail the premium notice, did not have to confirm that anyone actually received it, and that resolved issue one in favor of the insurance company. No money owed to the widow. She just lost $750,000. Issue two, the reinstatement. Was it even a reinstatement? The court held no, the reinstatement was invalid because you cannot insure a life that has already ended. Issue three, the arguments between the widow against the friend trustee. Did the trustee meet the standard of care? And separately, can he defend against the argued breach of fiduciary duty by bringing in contributory negligence, factually and legally? Factually, there are a number of things the insured dentist and his wife could have done that separately would have prevented this tragic outcome. But did the wife legally have an obligation to do those things, and can the trustee use that as a defense? In other states that have addressed the issue, the answer would be no, but this has not been litigated in Washington, D.C. You decide. How does the widow get some or all of the $750,000? Well, she's not getting it from the life insurance company. Issue one and issue two were resolved in favor of the life insurance company. The only path left is her separate lawsuit against the friend trustee. The widow and her lawyers filed a motion for summary judgment. It was denied without prejudice. What that means, they have to go to trial on certain issues, but without prejudice, left the door open to refiling. The district court judge took a unique approach. Normally, local rules prevent filing multiple summary judgment motions. You usually don't get the opportunity to file successive motions for summary judgment that could end the case without bringing it to a jury. In this instance, there were two issues that remained open even after the widow and her lawyers filed for summary judgment that the district court invited them to refile on to possibly avoid a trial. At this moment, what would you do? These choices: to file another motion for summary judgment, to settle, or to go to trial before a jury. They settled. The two open issues that the district court highlighted in its denial without prejudice of the wife's motion for summary judgment: does Washington, D.C. law permit a trustee to assert a contributory negligence defense? The wife and her lawyers filed for summary judgment. The trustee and his lawyers responded. Apparently, in that response, they argued contributory negligence because it's an open question in Washington, D.C. In other states and other federal courts that have considered it, it has been rejected. The widow and her lawyers, in their reply brief on the last page in just one paragraph, pointed out that contributory negligence shouldn't be permitted in Washington, D.C. And that's one of the reasons why the district court judge denied their motion for summary judgment without prejudice, inviting them to refile with that issue fully briefed. The second issue invited for rebriefing and a separate motion for summary judgment is whether the district court could decide as a matter of law the standard of care applicable to this irrevocable life insurance trust. These were the cases cited by the wife and her lawyers. We have Colorado and Utah both rejecting a contributory negligence defense, breach of fiduciary duty claims against the trustee, and two federal court decisions, both in New York, also rejecting the defense. But Washington, D.C., this remains an open question. Because this case settled, it did not go to trial, and there were no additional summary judgment motions filed. We don't know what Washington, D.C. would do. We have a good insight that it is unlikely contributory negligence would be adopted, but that issue has not been resolved. There's one sentence that would have changed the outcome on these facts and prevented the need for any of this litigation, and simply paid the widow $750,000 in life insurance proceeds when her husband unexpectedly died in January of 2010. We're going to look at this from a counterfactual, hypothetical perspective because this sentence was missing from the actual trust documents. When we looked at the language in the irrevocable life insurance trust itself, there was a clause requiring the grantor, that's the insured dentist, to receive premium notices from the insurance company. The problem for the dentist and his wife is that the insurance company, even though it had a copy of the irrevocable life insurance trust, it wasn't a party to it and it wasn't governed by it. Who was governed by the irrevocable life insurance trust? The grantor, the insured dentist, and the trustee. What was missing from the irrevocable life insurance trust itself was a sentence that required the trustee to contact the life insurance company and make the life insurance company send premium statements, shadow statements, or an additional login concerning this life insurance policy and the status of the premiums owed and paid. That one sentence would have changed everything in two ways. First, it would have created a redundancy, more than one set of eyes, more than one postal address to actually receive the premium notices. But separately, if the trustee was required in the irrevocable life insurance trust to take those steps and failed to do that, it would have been a slam dunk summary judgment motion that he breached his fiduciary duty. Those two ways would have helped fund the $750,000 in life insurance proceeds, either directly from the insurance company or direct liability to the friend trustee himself, without the need for years of litigation. Who needs to hear this? Your clients with irrevocable life insurance trusts. Currently, the estate tax exemption is higher than it had been previously. When the exemption was lower, an irrevocable life insurance trust was a common method recommended to reduce the taxable estate. And that's why it was probably created in this factual circumstance in 1993. You have clients who have irrevocable life insurance trusts who is receiving the premium notice mailings, who has login access to the status of the life insurance policy's premium. Have the premiums been paid in full on time? Is that policy in effect or has it lapsed? How long is the cure period? It's probably not much longer than 31 days. All of those things need to be looked at, and that means you need to start making phone calls to your clients that this may affect. That's something you can help your clients with this week. Takeaways for the insured and their families. When you transfer your life insurance policy from your personal ownership to an irrevocable life insurance trust, you are no longer the person communicating with the insurance company. Instead, because the trust owns the policy, the person the insurance company will communicate with is your trustee. Make sure you personally and your beneficiary, is it your spouse? Is it other members of your family? Make sure you and they have access to the login for this life insurance policy, or at least shadow statements of the status of the paid premiums. This is critical information to make sure it's up to date right now and add those redundancies so this doesn't happen to you and your family. For estate planners and lawyers, we have the triple problem of choice of law. The life insurance policy itself has a choice of law that probably controls. The trustee who doesn't update his mailing address with the insurance company, if that person's the only one who knows about and is the only one the insurance company communicates with, that causes a problem. And then compounding the error is the trustee calling the insurance company without disclosing the death. Contributory negligence, probably not a successful defense in the states that have considered it. It's been rejected. It's an open question elsewhere. Where an irrevocable life insurance trust does not provide protection. That's another takeaway from this litigation. Your life insurance premium notices should not be dependent on one person's mailing address, not yours, not your spouse's, and not the trustee. There needs to be redundancy built in so that the second or third recipient is the one who could alert everyone that the premium hasn't been paid in full on time. The beneficiary lacking notice of premium status. The beneficiary doesn't get notice unless the owner of the policy, whether it's you or your irrevocable life insurance trust through the trustee, makes that happen with the life insurance company. And then the only tracking system, there should be redundancies. It should not be based on the physical mailing address of one person. Client conversations to start this week. This is a topic for you to reach out to your clients as a checkup to make sure everything's fine or to catch this significant gap if a premium has been missed. You're going to look for clients who you know have irrevocable life insurance trusts. Confirm with your clients who besides the trustee has access to the life insurer's login or the physical policy premium notices that are mailed out. Is the premium payment on autopay? That also would have prevented what happened here. When did anyone last log in? The trustee, the insured, or the beneficiary? Multiple layers of redundancy are available. Autopay, beneficiary with read-only access online, courtesy duplicate notices, also known as shadow statements, and confirmation. Is the premium paid annually, biannually, quarterly? How much is owed? When is it due? How many days are available to cure? If the insured is still alive, and even if the 31 days have passed, reinstatement may be possible, but not if the insured has already passed away. Thank you for joining us. Stay tuned for a preview of our next episode. What happens on appeal when a Massachusetts divorce court reaches into a Michigan irrevocable trust and pulls out $1.17 million for the ex-son-in-law, despite a spendthrift clause? An independent trustee with sole and absolute discretion. The wife's out-of-state divorce made her mother's divorce-proof trust design the primary funding source for the $1.17 million property division judgment payable to the ex-son-in-law over 10 years. Shouldn't that irrevocable trust interest have been untouchable as separate property? The Massachusetts Appellate Court had to decide that exact question in the Jones case. Here's the million-dollar problem. Before the divorce, the mother's GRAT had terminated, and the wife's sub-trust was funded and running under Michigan law. The independent trustee had the power to postpone every distribution to the wife for her entire lifetime. The feature that was supposed to make her interest a speculative expectancy too remote for any divorce court to reach. But buried in that postponement provision was one verb with the power to decide the appeal. If you advise clients whose families build trusts like this, the Jones appellate result affects your client files, not just this family. In episode 111, Irrevocable Trust Litigation, Busted in Divorce, Son-in-Law Gets $1.17 million, we examine how one verb in a postponement provision challenged the divorce-proof trust design on appeal and analyze the appellate court's reasoning. Join us to see how it litigated and subscribe so you don't miss an episode.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.